Good afternoon or good morning, depending on which time zone you're in. We'd like to welcome you to today's presentation of the ACEDS webinar, Freedom of Information and Public Records, Making FOIA Information Ready for the Public. My name is Jason Krause. I'm with ACEDS, and I'd like to take a brief moment to welcome all of you on the call who are new to ACEDS. ACEDS, of course, is a membership association, and we're committed to promoting eDiscovery skill and competence through training, education, and networking. We also offer the Certified eDiscovery Specialist credential, which is held by more than 1,000 practitioners in the US and globally. You can join today and start receiving a number of benefits exclusive to our members, including our news content, members-only webcasts, our weekly newsletter, members directory, and special benefits from our affinity partners. I'd also like to take a minute to remind everyone that it's still possible to register for the ACEDS 2016 eDiscovery Conference. This year it's April 18th through 20th in New York. And I encourage everyone to check out the sessions and presenters that we're lining up. Got an absolute murderer's row of some of the most impressive eDiscovery judges and general counsel and top experts in the field. So. But with that, I'd like to turn it over to today's moderator, Mary Mack, the Executive Director of ACEDS. Mary, if you want to take it away.
Thanks, Jason. And I want to welcome everybody to this wonderful webinar that ZyLAB is gracious enough to sponsor for our members and those of you who are considering being members. We're absolutely thrilled to have Dan Metcalfe with us, who's a pioneer in FOIA, who will be able to give us not only what's happening now, but some insight into how things happened before there were resources. And at the end of our webinar, we will have Jan Scholtes, my former colleague and founder of ZyLAB, who will give just a short abbreviated introduction to some of the technology that you can bring to bear for FOIA. There'll actually be a whole separate webinar for those of you who are interested in the technology that you'll be able to register for at the end of the webinar if you wish. But this webinar, as we move through, is going to be substantive content heavy. And take a look at this bio. Dan Metcalfe, pretty much, I want to say, wrote the book on FOIA, but one of the next slides will show you some the location of some of his wonderful work. He has worked at the Department of Justice, or he did work at the Department of Justice for over 30 years, and he's going to talk a little bit about how in the world did he ever get to create an Office of Information and Privacy when he did, and how does that reflect on the challenges that agencies face today. And you can see he supervised the defense of over 500 FOIA and Privacy Act lawsuits. So he knows his stuff. He's a teacher, and some of his resources for his classes are also going to be part of this slide deck that you will have. And I was absolutely amazed when I went to these sites, the DOJ FOIA guidelines and collaboration on government secrecy. What I'd like to tell you about those resources, and Dan is going to speak to them as well, they're bite-sized resources. So they're in outline form, so you can go directly to what you need to know, when you need to know it, and they are absolutely phenomenal resources, those top two. And then next week, of course, is Sunshine Week, and so this webinar serves as a kickoff to Sunshine Week in the federal government. We're going to hear a lot more about FOIA in the news, and we've got the leading expert here. So, Dan, tell us a little bit about when you were considering forming the Office of Information and Privacy. What gave rise to that, and how was the idea received by a government that in the past would want to keep everything secret?
Well, first, Mary, it's good to be with you, and I'm blushing a little bit with an introduction like that. I can't say that I'm a pioneer going back to the enactment or even the first effectiveness of our Freedom of Information Act in 1967, because that's now almost 50 years ago, and I'm not quite that old, but I did start working with the law almost 40 years ago in 1976, and was a trial attorney specializing in FOIA and Privacy Act litigation for several years. And the genesis for the formation of the Office of Information and Privacy, OIP for short, was in the first year of the Reagan administration. There was much dissatisfaction with how agencies had been handling, or perhaps one could say mishandling, FOIA administration and litigation after our major amendments. And by that I mean to say the FOIA was enacted in '66, took effect a year later in '67, but there were major amendments in the wake of our Watergate scandal in 1974. And by the late 1970s, there was much dissatisfaction with that. And having been a trial attorney in the civil division working in that area, and also having worked on legislative reform since 1979, I guess, the Reagan administration folks decided that they wanted to create a strong consolidated office to focus on the Freedom of Information Act, not only within the Department of Justice and its 40 components, one of which is the FBI, very large, but also the 99 other federal agencies government-wide, because the Attorney General has a government-wide policy responsibility for FOIA interpretation, administration, and oversight, and the like. So I was not a political appointee. I'm always clear to say that. I was a career senior executive appointee, heading up, starting off originally with someone else, this office that just then zoomed off in size and in activity and in effect. We did a lot of different things to greatly enhance the administration of the FOIA. And frankly, I had such a great job. I enjoyed it so much, and I was apparently lacking in imagination, and I stayed as a director of that office for more than 25 years. And then I always knew I wanted to teach law, so I was lucky. I was started at a young age. I retired 9 years ago and have been at American University ever since. But the genesis was to have a coherent, consolidated approach where any agency could call in to one set of people and get the same answer, get consistency and uniformity, and really know that you're getting the expert analysis and guidance on how to interpret the FOIA, how to administer the FOIA, and then ultimately also how to handle it in litigation.
Well, fantastic. And fast forwarding into more of the present time, how do you think the government is doing right now responding to FOIA requests? And what's different now from when you started?
Well, let's see. I'd say the major thing that's different now in the Obama administration is that it is a quote-unquote liberal, progressive, democratic administration rather than a more conservative Republican administration. FOIA outcomes ought not to hinge on the political party that happens to be in office, but it is no secret that Republican administrations tend to be more protective of information, and Democratic administrations tend to be freer and more oriented toward disclosure. Now, we had a Democratic administration under President Clinton with an Attorney General, Janet Reno, who was very, very pro-disclosure. I can't emphasize that enough. And things just turned around quite a bit from how it had been during the 12 preceding years, Reagan 1, Reagan 2, and then Bush 1, as I call it, Bush the Elder. Then we had Bush 2, Bush 3, and now when President Obama came on board, the expectations were exceedingly high. In 2009, the FOIA requester community, after 8 years of the Bush administration, the younger Bush administration, had great expectations, and then those expectations were very much enhanced when President Obama came out with what were called day one issuances, memoranda saying we're going to disclose information, we're going to be the most transparent administration in history, et cetera, et cetera. Well, there has been disappointment in that. And as a matter of fact, at the secrecy center that I ran at my law school, we even had a series of programs every January 20th, just looking at the progress of the Obama administration in making more and more information disclosable, being less secretive. And the first year, it was a matter of the White House saying, well, give us time. It takes time for us to turn the battleship around, so to speak. But by the second year and the third year, and now we've gone further along, there's been enormous disappointment in the openness and government community that the White House and the Justice Department have not been nearly as open as the expectations would have led one to expect.
And what do you think the obstacle is to being more open? Is it a technology issue? Is it a process issue? Or is it a content issue, do you think?
I'd say in part it's dollars, because backlogs of requests are a big part of that. Requesters get very unhappy when agencies take longer than the statutory time limits to disclose information. But in other respects, there have been, shall we say, some difficulties or scandals or areas of concern, and sometimes even the Obama administration appointees have been very, shall we say, narrow and secretive in their approach. There was a head of one agency, for example, I won't mention the name, but the initials are EPA. That agency had a head who actually had a secret email account. And this is long before Hillary Clinton had anything like that. And people looked at that and they said to the White House, hey, we thought this was going to be different than how it was in the past. How is it that this sort of thing is still going on? Part of it's just human nature. I have to admit that, and you're going to hit that not just in the United States, but worldwide. People tend to be secretive and proprietary about government information. But I will admit to personally being surprised that the Obama administration has not been as pro-disclosure as it proclaimed to be, and frankly not nearly as much as I know firsthand the Clinton administration was, because we made a lot of what we call discretionary disclosure back then under Janet Reno as Attorney General. We applied something called the foreseeable harm standard that I can explain in greater detail if your listeners would like.
Yeah, I actually would love for you to explain that, maybe in the context of when you have a question to or a request, a FOIA request, what the process is, and then that foreseeable harm. I would love for you to explain what that is in the context of the process flow.
Okay, well, let me try to take you through the process, and if I dip down into too much detail, please stop me, okay? Don't let me get more detailed than you would like me to be. The first thing that happens when a request comes in, it gets logged in. That's an administrative step, and theoretically the clock starts running on the FOIA. 20 working days is the norm for a full response. And then the next thing that happens is that someone at a little bit higher clerical level will read the letter, and interpret the request. And as a general rule, conservative Republican administrations tend to be a little bit more conservative and less favorable, shall we say, in interpreting requests, and Democratic administrations are more so. But that's the first step, interpret the request. Then the next step is a very, very big one, and that's to search. Search for records responsive to that request. Sometimes the request will specify just one record, and it's very clear, and the search is simple. Sometimes the request will say, well, I'm looking for this general subject matter, but this in particular. And the FOIA officer has to go and not only search within his or her own expertise, but go to a program office within the agency and say, hey, folks, you deal with this subject matter every day. Where are records that are described in this request letter that I'm holding here? And let's gather those records. So it's searching for records, sometimes manually, sometimes electronically, sometimes both. And then you could think of it as just putting on a table a pile of records that are there. And it's easiest to talk about it in the old-fashioned paper world form. In other words, that you've got, let's say, 100 pages of records that are on that table, and they are determined to be responsive to the request. Then the next step that's taken is something that in the FOIA community, FOIA agency folks, will call processing the records. And that simply means looking at the records, document by document, page by page, paragraph by paragraph, even sentence and segment by segment, to see if there's any sensitivity to any of that information. Now, what does sensitivity mean? Well, it means that if it were disclosed, not just to that requester, but to any requester, because release to one is fundamentally release to all, would there be harm? Well, what does harm mean? Well, that's where the FOIA exemptions come into play. There are 9 FOIA exemptions and then several subparts to the law enforcement exemption, and they deal with different types of harm. Harm to a business interest, harm to a personal interest, harm to an institutional interest. And the exemptions and the cases that have been decided under the exemptions establish standards according to which decisions are made. Does this fall within exemption 4 or not? Does it fall within exemption 5 or not? And just to speak very generally, at least at first, agencies have to decide, are any of the portions of these records, and sometimes it's an entire page or an entire document, of such nature that they fall within an exemption. Then they do have one additional step as a matter of policy, and that's what I was speaking about with respect to the foreseeable harm standard. Way back in the Clinton administration, I came up with this idea for Janet Reno. We put in a memorandum that she signed and President Clinton signed something that went with it that basically said to agencies, okay, you go through the process, you determine if something is exempt. It falls with an exemption or not. If there's no exemption, it gets disclosed, of course. If there is an exemption, don't end the analysis there. Consider the information further and consider whether there really can be foreseen some actual harm from disclosure. Sometimes something can fall within an exemption technically, but there's really no good reason to withhold it. And I can give you a concrete example of that. Under exemption 5, that's the one of the institutional exemptions that protects privileged information, and the most commonly used privilege is what's called the deliberative process privilege, agency decision-making process, deliberations. And you can have something that is pre-decisional in its character, and it indicates what the agency's thinking was, and theoretically there might be concern that if it were disclosed down the line, someone might be inhibited from giving full advice the second time around. But if you look at that, you can see, well, that's 7, 8, 10 years old. No one's going to be inhibited. Does it technically fall within the deliberative process privilege and therefore within exemption 5? Yes. Is an agency legally within its rights to withhold the information? Yes. Will a court uphold that in court as within an exemption? Yes. As a matter of law, it is exempt. But then as a matter of policy, does it really have to be withheld? Is there really any harm that can be foreseen for that information at this point in time? And that's an example of the foreseeable harm standard being applied for a particular exemption.
So what you're describing is a multi-layer process. And so you've got the people receiving the request, you've got the search and the gathering of records, you have that initial processing, as you call it, which in eDiscovery language would probably be more like a review. And then you have a pre-production step where if something is withheld, seeing about foreseeable harm, and if there isn't any, erring on the side of disclosing. Who are the people, or the titles, I should say, or the job functions? Who is actually doing those things, and is it something that's a budgeted and accountable position, or is it people who are doing the best they can within their job functions, and then also trying to do this as sort of an unbudgeted mandate?
Okay, let me try to unpack that question, because that probes into quite a bit. You're correct in that sometimes, depending upon the size of the agency and how much FOIA business it gets, so to speak, there won't be a complete set of people working full-time on different parts of the process. But let me take, just to begin with, a large agency or component of an agency. I mentioned the Department of Justice has 40 components. My office was one of the 40. But the FBI receives a lot of requests. And if you made a request to the FBI, the first step of opening the envelope and logging it in, that would be taken by probably a GS3, maybe a GS5, relatively low-level clerical person. And then the next step, interpreting the request, that too would probably be a more experienced clerical person, maybe at the GS7 level, where interpreting the request matters. Then the next step of searching for records, that would be an even more experienced person with greater expertise, greater skill at maybe the GS9 level. Then let's imagine those 100 pages come back and they're sitting on the table and they're going to be what I call processed. Well, that's a 2- or 3-step process at large agencies with full shops. There'll be people who work full-time, paralegals at the 9, GS11, even GS12 level, who do nothing more than analyze records for sensitivity. And then there will be supervisors, people who will look over their shoulder, so to speak, who will maybe not look at everything that is blacked out or allowed to be or slated to be disclosed, but will look at least a sample of that as a double check, so to speak. And then there often is an even second level supervisor, certainly the person who signs the letter. That person has responsibility for making the final decision. It's his or her name that goes on the letter as the denial authority if anything's being withheld. And that's someone who might say, oh, how can I be sure that they did go through a foreseeable harm analysis? Well, let's double check here and there. So if you have an agency or department or a department component that's large enough, dozens of people working full-time on the FOIA, That's how that works. If, on the other hand, it's a much smaller operation, either a smaller component of an agency, say we're the Solicitor General's Office of the Department of Justice, or a small one of the 100 federal agencies, the Overseas Private Investment Corporation, they don't have people, anyone at any level of this, who work on FOIA matters full-time in any respect. It's part-time. It's sort of in the what's sometimes called the other duties as assigned category. They will develop expertise over time. It's not as if they don't know anything at all and they're just wandering in the desert. But the volume of activity is simply such that they don't have to work on FOIA full-time. They'll work on agency ethics matters or records management matters or things that are maybe even not as closely related in a general counsel's office.
So that process and the number of people that would be handling the same request, you spoke earlier about 20 days, and that's a short period of time for that complex a process. How are agencies here handling that?
Well, to give you just a little bit of quick background, it used to be only 10 days until 1996. And the word day there means working day, not a weekend or a federal holiday. So roughly 20 working days is 30 calendar days.
About a month, yeah.
About a month, yes. But that is what the statute says. There is a mechanism whereby the agency can invoke additional 10 days, those being 10 working days, so 15 calendar days, under certain circumstances, such as where they have to do a wide-ranging search to locate records. So it could go to as many as 45 calendar days if the agency invokes that additional 10 working days. And if you look at all of the spectrum of agencies, when I started back in the 70s, I think we had only about 80 federal agencies, as I recall. And it was not long before I retired 9 years ago that we hit the 100th federal agency. So if you look at across the spectrum, you have at one end some agencies that are so small and non-controversial, and that their FOIA business, the interest as expressed in FOIA requests, is so relatively slight that they're able to meet the 20 working days. They don't have many requests going at the same time. Sometimes they don't even have more than one going in process, pending at any one time. Then you go to the other end of the spectrum, and here we're talking about law enforcement agencies, intelligence agencies, I would say diplomatic with the State Department, and in some instances agencies that deal with commercial information like the Food and Drug Administration. There's a lot of sensitive business information, but that's a fourth category. The big three are law enforcement, intelligence, and diplomatic. They receive so many requests, and requests that are on average more complex than the average request government-wide, and more to the point, they have records that are more sophisticated and detailed and sensitive in their nature than the average record at the average federal agency, that they have enormous difficulty meeting the deadline. And as a matter of fact, that even understates it for me to phrase it the way I did just a moment ago. Those are agencies that maintain what are called backlogs of requests, where it's not just a matter of how long it takes to process the one request in particular. Once that letter is opened and then all those people start doing what I described earlier, there's time spent waiting online on a queue before that request is even reached. Now, if those agencies had an unlimited budget that were applicable for FOIA administration, then there would be no queue, that's for sure. It might take long in a particular case to process a particular request because of its complexity. That could still take more than 20 working days. But there would be no backlog of waiting in a queue online for the ones ahead of you in time to be handled first. Agencies do try to divide their queues into quick responses, medium size, and complex requests. And that does help a little bit if you're a quick response type requester. By that I mean to say is what you're asking for is not very complex at all. They should be able to search for it quickly and then process it quickly and get it out to you. That helps those people. But what it does is take the longer project requests, the more complex ones, and it can turn those requests into not just weeks or months, but even years waiting online to get to the point where the agency even opens the letter.
And did I hear you right? It's the time from which they open the letter that the clock starts?
No, I should have been more precise on that. I used the phrase logged in, and sometimes the day the letter is opened is not the same as the day that it's logged in. But the starting point is when someone takes a letter that has been removed from an envelope, or let's say it came in by fax, and goes over to either a book if it's done manually, or nowadays more commonly an electronic database, and makes an entry that memorializes the receipt of that request. Mm-hmm. And that's the date that will be regarded as the date that the request came in.
And so the backlog, I've seen some tweets out there from reporters that, you know, the several year or couple of year backlog. Are there penalties for not complying within the time frame? Let's go time frame first, and then we'll go to the substance of the request second.
All right, time frame first. There was a time when there was a simpler answer to that, but now under the 2007 amendments, there is a penalty provision. Let's say you make a request, Mary, and it's to an agency, it doesn't matter which one, and it's a simple request, relatively simple, and you describe the records you're seeking, and the agency receives it, logs it in, does a search, but it takes a little bit more time to search for those records than the agency would have hoped, and by the time that pile, maybe it's a small pile of records, comes back to sit on the processing table, it's now the 22nd day. Mm-hmm. Okay. If that agency did not invoke the additional 10 working days, then that means that as of the 22nd working day, the agency is in default. It has breached that deadline. And there is a provision as of 2007 that says if an agency breaches any deadline, and that's the initial 20 working days, maybe the additional 10 working days if that's invoked with a letter, or it could be administrative appeal deadline. We haven't spoken about that at all, but there's a deadline there. Or it could also be the deadline for considering whether to give you expedited processing of your request, which we haven't spoken about yet, but suffice to say at this point, anybody can make a request for expedited processing, and believe it or not, under the 2007 amendments, if an agency doesn't decide whether to expedite within 10 days, that's a breach of a deadline, and that number 10, that word day, is not working day, that's calendar days. So if you wrote a request as, say, a member of the media, and we wanted expedited processing, and they didn't decide whether to grant you expedited processing within 10 calendar days, they would be in breach. Now, what does that mean? It means one thing traditionally with respect to litigation, which is that you have what's called constructive exhaustion. You don't have to wait for the administrative process to go further. Rather, if you're eager to get those records and to be as aggressive as you can go right into court on that 21st working day and start a lawsuit and apply pressure to that agency. The other penalty, the one that I referred to as coming into play in 2007, is that once an agency is in breach, it cannot charge any search fee. Agencies can charge fees for different parts of the process. A search fee, a duplication fee, just a copying fee is a better way to put it. But if an agency is in violation of any deadline, then the requester gets the benefit of not having to pay a search fee. Now, I probably should add one more thing on that, which is that under the 86 amendments, there are no search fees for media requesters and academic requesters, for example. They never ever have to pay search fees, period. So what happens when the requester who has a deadline breached wants the penalty, and then the agency says, oh, wait a minute, you already have your penalty and that we're not charging you search fees. Congress said, no, no, no. In that case, there's a further penalty and there's no copying fee whatsoever. So for media requesters where the deadlines are breached, there's no search fee and there's no copying fee. That's a relatively small penalty for agencies. It doesn't usually come out of the agency's budget. It doesn't have the force and effect, you know, the old carrot and the stick. It's not that much of a stick, but that's all that the FOIA offers. And the only thing I guess I'd have to add to that, Mary, to round out the discussion on the disincentives for agencies is that the head of an agency can be called up before Congress and question, why the heck are you taking so long to respond to requests? Why are these requesters coming in here and complaining that you're not coming even close to the 10 working days? That does happen from time to time.
Well, let's go to the opportunity for an agency to charge. Is the search, for the search charges, is that like an hourly rate or something like that applied to how long they think the search will take, or
no?
What is that?
Okay, it's close to what you said. First of all, it's done almost everywhere by quarter hour, and second, it's done according to what is actually consumed. In other words, although agencies will estimate fees sometimes in advance, but what is actually chargeable, properly chargeable, payable by the requester is the time that is expended in the search process. So if we're talking about an average requester, let's say, not a member of the media, not a favored requester, not an academic, anything like that, and then the search enterprise begins, the first thing that you would want to know as that average requester is, believe it or not, you get the first 2 hours of search for free. By the way, I should clarify one thing. This is not for commercial requesters. This is just for requesters that are neither favored as media, for example, nor disfavored as commercial requesters. The average requester gets the first 2 hours of search free. And then whatever amount of search is actually consumed or conducted thereafter, that's by quarter hour, depending upon the grade level of the people who do the search. And you can look, any requester can look in agency regulations. That's the great thing now. Agencies have websites for purposes of their administration, and it's a lot more accessible to the average requester. You can look in the regulations. You can look, agencies have used something called a reference guide to the basics of the FOIA at that agency, and you can see how much is charged per quarter hour depending upon the type of person who does the search. Then there's the copying cost. I should mention that similar to the 2 hours of search for free, requesters get 100 pages or their electronic equivalent, 100 pages free, no charge. Most agencies still charge only about 10 cents, maybe 15 cents a page. So that means the average requester will be able to get an economic benefit that way. Plus, beyond that, the 100 pages or the equivalent and the 2 hours of search or its electronic equivalent, there's also a mechanism whereby agencies calculate the actual cost to agencies of processing a check. And it varies a little bit from agency to agency. And there's a basic component of it, which is part of it is over at the Treasury, okay? But agencies will calculate, let's say that on average, it costs us $17.50 to process a check if we charge the requester and the requester writes a check and it comes in. So whenever there's a fee, a charge, that's that amount or less, it's free. So when you add up the 2 hours of search time or their equivalent, the 100 pages, and the equivalent of, let's say, $17, $18, whatever it might be at any particular agency, that does add up and makes for a lot of requests that are within that zone, so to speak, where there is nothing charged, nothing has to be paid.
And so when you were talking about the copying charge, Dan, is that a physical paper copy or is that also an electronic record copy?
It's both. And back in the days, and whenever I teach my class, I try to keep things simple. You know, imagine that it's still paper copy like that, just to describe the process. But you're right. It could be a piece of paper at 10 cents a page, or it could be the electronic equivalent. And there are circumstances, as I'm sure you can imagine, when a lot more information can be made available for the economic equivalent of 100 pages, with, let's say, $10 at 10 cents a page. So agencies nowadays are able to make information available in electronic media form far more efficiently, far more economically than in the past. Now that does lead to another little wrinkle, I guess, that I feel obliged to mention. There is a legal issue sometimes as to whether the requester can have the disclosure in the particular electronic form that the requester prefers. In other words, we put paper aside. There's going to be disclosure in one electronic form or another, but the requester would like it in Form A because that's most usable or compatible for that requester, and the agency regularly releases it in the Form B. And Congress did address that issue 20 years ago in the 1996 amendments and said that an agency has an obligation to let the requester have his, her, or its preference of form or format of disclosure, so long as, get ready for it, the information can be produced with a reasonable amount of effort. Now, you notice the word reasonable there. That is a very commonly used word in legislation, and it does appear a number of places in the FOIA, and obviously it leaves wiggle room. Congress didn't define what a reasonable amount of effort is, and it's something that agencies and requesters will argue about sometimes back and forth. But I can tell you this, in the 20 years, almost 20 years, since that reasonableness standard came into play for electronic records, I think requesters have been treated reasonably. By that I mean to say, I think agencies have not been so stubborn as to stand on whether something was reasonable or unreasonable. I think requesters have been getting reasonable treatment. That's my strong sense of it.
Yeah, so for our eDiscovery people, that means flexibility of production, of course. We have a question, Dan, if you could clarify how long a request can sit in the envelope before it's opened?
Oh, I emphasize that only because we were talking about the 20 working days, so sometimes there can be a dispute, is it day 20 or day 21? An agency has an obligation to act reasonably quickly to open the envelope and log it in, not just let the envelope sit there. In other words, when I say something is in a queue and waiting online, it will be logged in. But I know of situations in which requesters have been very anxious, very aggressive, have gone running into court on what the requester thinks is the 22nd working day, and found that no, actually it wasn't logged in until 3 calendar days after you thought, so therefore it's not 20 working days yet. So I guess I would encourage FOIA requesters to leave a little bit of cushion in that. I also would encourage them, just as a general rule, if time matters, sometimes it doesn't, but oftentimes it does matter. Take 2 steps. We sometimes call it belt and suspenders. In other words, send the request in by fax, and then also send it in paper form. The fax, if it's working just fine, will get it logged in most quickly. But the paper form is a greater guarantee that it will get logged in, that someone just didn't misplace something in the fax machine. So I always tell my students, and back in the years ago, clients, belts and suspenders, double track it, fax and paper form as well. And I should add, about half of agencies now will allow requests to come in electronically, either in email form or in filling something out online. They are not required to do that as a matter of law. So if one of your listeners goes to an agency and says, wait a minute, I heard Dan Metcalfe talk about doing it electronically, what gives here? The answer is that agency is not as nice as other agencies, because they are not required to do it by law, but roughly half of them do allow that to be done.
Okay, I have one more question for you, Dan, and then Jan, if you'll start getting online so that we can finish up with, oh, you're on, good, good. So the last question, Dan, that I have from our listeners is, what advice would you give for those that are supporting agencies and they're heading towards the end of 2016 with a new presidential administration? Do you have any advice for folks that are stewards of information in those circumstances?
Okay, you used the phrase stewards of information. I would say make sure that you're working hand in hand with 2 other types of people at your agency. Years ago when I started, it was just the FOIA specialist. Then with the electronic age, we try to get the FOIA people working with what we then called the IMF program. IRM, Information Resource Management, the data folks, the IT folks, you'd say now. But I'd also add to that the records management folks, the people who are responsible for records being maintained in a certain way so that they are available for FOIA requests and readily searchable without great cost to the agency or the requester. And certainly now that we're dealing with electronic mail and searching for things like that, having the records management folks and the FOIA folks work hand in hand, that's very, very important. And if anyone has any doubt about that, I just suggest that you go over and take a look at what's happening at the State Department.
Yeah, and so all of this takes some technology. And Jan, can you speak a little bit about some of the case studies that you've seen and where technology is brought to bear on this timing problem, this volume of information, the time it takes to process it or apply the exemptions, and then to produce it?
Yeah, okay. Yeah, thank you very much, Mary. Also, thank you very much, Dan, for the excellent overview and a very clear explanation of the FOIA process.
Welcome.
What we try to do at ZyLAB is we try to look for automation, and we try to bring the time period back or make it as easy as possible to make the time periods without the need to scale up the amount of manual labor tremendously by using automation. And if you look at the slide, there's a couple of different areas where automation can really make a big difference. First of all, in what Dan called search, of course, full text search, exploratory search, refined search with advanced hit list, hit highlighting, being able to search your paper records or your images using fuzzy search and a variety of different search techniques really can help you to find the responsive documents as soon as possible. Now, of course, you need to facilitate the searcher because, like Dan, like you explained, so sometimes people specify keywords that they're interested in, but sometimes they don't, and they define a pretty abstract concept and use the search for the collecting, classification, sorting of the technologies is really interesting. The other thing is, like, you know, instead of disclosing paper, if you can disclose in electronic format like TIFF or PDF, we've had clients, several, that said that only the saving of the printing cost will pay for the ZyLAB system or for a good FOIA system because they no longer have to print everything. Now, where you can make tremendous amounts of productivity revolutions, as one of our clients called it, is with our auto redaction. Redaction is very painful, as you described, during what you call the processing phase, and finding which information is harmful or which information is potentially harmful or sensitive. Redacting is troublesome. Now, some of this information you still have to do manually, especially if it's like kind of a complex type of sensitivity. But if it's like personal identifiable information or protected health information or other type of exemptions, there's a lot of technology, especially text mining technology, that can help you to recognize it. Think of social security numbers, phone numbers, names, addresses, certain health information. And what we can do is we can not only redact it, we can also replace it with an overlay which mentions which exemption rule was used. And we can even, for instance, if we have individual names, we can even substitute the individual name not only with a black marker, but also with like a certain synonym, like number A or individual B or C or D, if that's required. So those are really, the deduplication as the third button is really something which, especially in email, can cause enormous amounts of duplicates. Typically 50 to 80% of email collections, especially when it's multiple custodians, can consist out of duplicates. So deduplication, exact deduplication, near deduplication is a huge time saver. So these are, to answer your question, Mary, these are really the ones that are used to make it easier to make the deadline. Now the middle one, if you allow me, I'll just continue. Is that okay?
Sure.
The middle one is more like what you described then, where you have to provide a page count. because sometimes you can charge a fee, and it would be kind of a waste of government resources if you are going to collect all your data. Then you have like 1,000 pages. You go back to the or 10,000 pages for argument. You go back to the requester, and then the requester says, "Well, that's too much. I'm not going to pay for it." And then you've already done all the work. And this is where we have a functionality to provide a virtual page count directly after the search. So what we're going to do is we're going to do a virtual TIFF print of all of the files. So the Word files, Excel files, PowerPoints. We're going to do a TIFF print. And then we're going to estimate how many pages there are. Now, this is not like a perfect estimation, but it's very, very close to the actual number of pages that will be printed at the end of the day. And then the requesting party can either accept this, refuse it, or modify the request, saving both parties a huge amount of time and resources. Now, the rules here are a little different in FOIA for the government and in public records request in cities and state level, but we can be very flexible, and our software can be configured depending on how the clients or how the customer uses it. Okay, we'll go to the next slide.
Jan, if I can just interject. Jan, if I can just interject.
Yep.
The point that you just made does fit very well with an aspect of the FOIA that involves negotiation between the requester and the agency as to the size of the request. Congress put language in there that fits with what you just said and encourages agencies to do exactly that.
Yeah. No, it's a very, very useful feature, and that's highly appreciated by our clients doing for the public records officers using our software. Now, where do we see in general possibilities for automation? Of course, finding responsive documents by using search, and then not just like standard search, but advanced deep search. Finding potentially confidential and privileged documents, finding attorney-client correspondence, finding third-party legal agreements, third-party information on the non-disclosure agreements. These type of things are reasonably easy to define how they look, especially if you work with certain outside counsel or certain attorneys' names. You have to configure this once, and then in the future, a lot of this information will be tagged automatically. And if you run into information which has not been tagged but should have been tagged, you can easily expand our rules library so the next time it will be captured and caught, and then so the system in a way learns and gets better every time you provide additional information. Privacy and data protection, we have used libraries that recognize a lot of different forms of PII. I already gave a couple of them, but also PHI. We actually did an effort once on the Enron data set, and we also found a lot of social security numbers and other files that were still in there, and we helped to clean the effort, the Enron effort. We did a press release on that. You can still read it if you are interested. And then there are various other exemptions and exclusions and exceptions, and how they're being called, depending on the type of legislation, depending whether, FOIA, there are a couple of, like you said, exemption 5, the PII. Did I repeat that right? Is that the one you said?
Exemption 5 is institutional concerns like privileges, but PII, personal information, that's exemption 6, privacy.
Okay, well, I missed one.
And then, so Jan and Dan, what you're talking about with these exemptions, is this similar to a privilege log that needs to be generated with the production? Is what's being withheld and why?
I think that's very true. We call that a Vaughan index, named after the first case brought by my colleague at the law school, Robert Vaughan. And there are strong, strong similarities between a Vaughan index for FOIA litigation purposes and a privilege log in discovery. You're exactly correct.
Yeah. Now these rules kind of change or different between FOIA and states and cities and counties. But in general, we see there's different types of exemptions. It's like there's draft documents. There's documents related to national defense, solely internal personnel rules. accusing somebody of a crime. These are just a couple of examples of exemptions. And in our software, we try to provide as many of these exemptions rules as possible, but it's also possible as an agency to define these type of exemptions yourself. Okay, next slide, Mary.
Mm-hmm.
Here's an example. I blew it up a little bit. What we do with our software, and we're going to organize a special webinar about this. Was it May 11th, I think? Where we're actually going into a lot of detail. And what you see here is our review interface. So this is where the processing starts, as Dan described it. This is your table, but now your table is filled with virtual facets, and each of these facets is a virtual pile of paper. And we have put all the pieces of paper together, which contain either PII. So you see there's PII passport, there's PII license plate, there's HIPAA medical condition, PII social security number. And there's a frequency count, and as a FOIA officer, you can click on it and you can immediately see, is this indeed something which contains PII, and then we can auto-redact it. You also see a couple of US FOIA exemption rules. You see the exact names that occur. So there's some information found related to US FOIA B5, or the other one B1 1.5. So we try to really automate this process and provide as much automation as possible. And organize the data in like virtual bins where a document can also fit in multiple bins, so there's as little risk as possible for erroneous disclosures. Okay, next slide, please, Mary. So,
and that
is
yeah, obviously Jan has not had time to go through a full demo of the technology that's available. So those of you who are interested in that, Jan, do you want to say a few words about what you're going to do in your practical hands-on webinar, where it's where you're free to show the product?
Yeah. In the what we're going to do together with Gettmann, our product manager, we're going to show how we actually support typical FOIA workflow. What Dan explained, the process. We're going to show you how that process is being implemented, from the identification, the collection, the searching, and then the processing of all the data, the review, the redaction. We're going to show logs on how disclosures are made. We're going to show you how we can do a virtual page count before an actual production is done. We show how we can produce in narrow accepted formats and PDF, and how you can also search former disclosures, and how you can tremendously reduce costs associated with adding staff, duplicate file creation, and paper file sharing. And that's going to be May 11th. And if you click on this link, you can register for the webinar.
Well, that's great, Jan, and I want to thank you, and I want to thank Dan for a wonderful webinar. We did have a request. There was a link for the DOJ FOIA material that we put out through the chat, but in the email that'll come after the webinar, we'll make sure that you get that correct link, and then also the slides for this webinar, and you'll have that opportunity to sign up for the May 11th webinar as well. I want to thank all of you for your kind attention today, for your questions, and we will see you at the ACEDS conference. Pre-conferences are on the 18th and the 19th and 20th of April, New York City, Grand Hyatt. Thank you.
Thank you, Mary.
Thank you.
Pleased to be with you.
Jason?
Thanks. And of course, just a quick reminder that the follow-up webinar for this presentation, as mentioned, is on May 11th. So I encourage everyone who enjoyed today's presentation to sign up for that webinar. And you can find a recording and copy of the slides on the ACEDS website on the on-demand section. All right. Thanks, everyone.